I can deny the motion. You're not getting out of jail today. You didn't learn anything from felony drug court because let me just explain something to you. Everybody in this court has a bad day. Ask you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just going to stop submitting you to drug testing. I'm not going to do any of this. Is calling 2021 CR 8476 State versus Beth Nicole Martinez. Could I have parties announced?
Ashley Jones for the state.
Route reporter for Miss Martinez.
Are you Miss Martinez?
Yes, ma'am.
All right. Did you review at the council? You have 10 days to prepare. Are you ready to proceed?
We are.
All right. And Miss Martinez, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beth Nicole Martinez who was placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes, state's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Bexar County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to prove true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Partially, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit. But I do not see any evidence of mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have any current on that to show that there's DPRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 UA was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite complete it up. Now we're gonna have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
So here's the thing I know about felony drug court because I used to be an attorney for felony drug court. All you had to do was pick up the phone and call them.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there, and the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser. It's about I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs. I may fall out of this program. That's what it's about. It's not I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just going to stop submitting you to drug testing. I'm not going to do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
At the time I was this overwhelmed, I had too much stuff going on. I was losing
Alright,
my
so
son's house.
Your decision with probation was what? With felony drug court? See, I'm trying to get you to point, because see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday, I get a call at 3 a.m. And you know what that call is? It's from my younger brother, and guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why don't you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left messages to everybody. Hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was a defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm gonna give you a choice. I can deny the motion. You're not getting out of jail today. You're going to do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long. I think that's the right choice.
Will I get my back time if I sign up?
Sure. So what do you want to do?
Do the TAP evaluation.
All right, so the court will deny the motion, alter and amend conditions to include in custody. There's to be a TAP evaluation. Follow all recommendations. And there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested, State?
Oh, yeah.
And is there anything else you need from the court? Miss, is there anything else you need from the court?
Amen.
All right, and there's to be no residents with minors. All right, thank you.
Thank you, Judge.
You're welcome.
Make him valid case, please.
Yes. 2023 CR 2023 CR 8101 State versus Celeste Suarez. Can I have parties announced for the record for the state?
State.
Defense.
Jason Todd for defense.
And are you Ms. Suarez? All right, so off the record, with regards to number 5, motion for discovery and inspection filed by the defense. With regards to number 1, the court is
granting that based upon the agreement of parties. It will exclude state's work product, but if necessary, the court will perform an in-camera inspection. All right, with regards to number 2,
Judge, there is none to my knowledge, but if I discover that there is, I will disclose it.
all right, that'll be granted. With regards to number 3,
State has already provided a witness list to defense. The only thing is we don't have personal addresses for the victims due to safety issues. We have for the officers and the school professionals, we have the school addresses, the work addresses, and work information. To the best of my ability, and if I find more information, I'll provide it.
all right, so the court, based upon the state's representation, do you have any objection to not including the addresses of the complainant?
Well, Judge, I understand not filing it in a public record. I also, though, I don't understand the safety issue of disclosing it to defense.
All right, so what do you want to do with the
If she-
address? You want to go out to the address of the complainant? Is that in some way related to the alleged offense?
If there were reports we wanted to know if there's been calls to the house, if we wanted to do research on the complainant, we would not. That being said, we have the address of the complainant, so that's not the issue.
All right, so you already have.
I have that address, but safety concerns for if there's more than the complainant, we need the ability to research these witnesses, and we need the ability to know what's going on regarding their
Well, my
testimony.
understanding is the only thing the state is not wanting to turn over is the addresses. Is that correct?
So it's the addresses of the complainants, and I'd have to look around, sorry, I don't have my witness list. It's the address of the complainant and complainant's mother, guardian.
Well, he says he already has the address of the complainant and the complainant's mother, so that will be excluded. You already have it.
And
Yes,
the
Judge.
personal addresses of the professional witnesses, but they are identified by the order placed to the best of state's ability. And if additional information comes, I will turn it over. I'm giving you your ready.
All right, with regards to professional witnesses, I'm assuming the professional address for their business. You don't need their home address, do you?
We do not, just the ability to contact them and reach out to them if that need should arise.
All right, I'm gonna notate that defense, has in its possession the address of the complainant's address, so that's not needed. So what I'm gonna order is that there is to be state, you're to turn over all the names and business addresses of individual witnesses. And if for some reason there is an address that you feel that you need, that is a person's personal address, just come back and we'll have a hearing.
Thank you,
But
Judge.
that'll need to be done, not at the last minute.
Understood, Judge.
Okay. Number 4,
To my knowledge, Your Honor, there is no informant in this case. If one becomes known to the state, we will disclose it.
all right, thank you. And let me ask you all this, is CPS involved in this or no?
Yes, Judge.
All right, so sometimes the confidential informant could be the person who reported it.
So CPS comes in after the initial report to law enforcement. I think, was it law enforcement or without CPS, I think?
I would have to look at the timeline. We know who told CPS. I will say that. I don't think that's an issue in this case, Your Honor.
All right, because if it is, then my ruling on this, granting it, I'm going to rescind that because that's supposed to be confidential.
I understand, Your
All
Honor.
right.
I don't think that's an issue, though.
All right, and number 5,
That's to number 5, Your Honor. The only issue state has is.
everyone, please whisper. And everyone, we're on the record, so no talking behind the court reporter while we're on the record. All right, number 5.
The only issue is the rank and badge number of the police officers. Some of them have changed agencies, some of them have retired. I don't have all of their badge numbers or rank. As to what information is current and that I can provide, I will provide it, but I don't have all their historical information for what their rank was. And I also don't know if he wants rank at the time of the offense, badge number at the time of the offense, future badge numbers. It's a little vague for me.
I guess my response would be to that if she gets updated information and she's talking to her witnesses, if we get to the place where we're prepping for trial, we need the ability to know where her witnesses are. If she's, I have no doubt she's given us what she has, but if she finds out something new, I think we do
Okay.
need to know that.
So as far as where her witnesses are, that would be taken care of with regards to defenses number 3. So do you really need to know the rank and badge numbers?
Yet the rank is helpful, but the badge number is important because if this law enforcement officer has moved to a different agency or within the agency, if we want to look them up and look up what they have, perhaps discipline or get information from the agency, I have found the easiest way is a badge number.
All right, so you don't need their rank.
I guess I don't need it.
All right,
It does.
so then if you have the rank, then give them the rank. But if you don't have the rank, then she doesn't have the rank. And it is vague based upon what she's stating. Do you want their rank at the time they were involved in this, or do you want their rank now? So if you have their rank, give it to them. If you don't have the rank, and if there's an issue, then just come back to the court. If you have their badge number, give it to them. If you don't have their badge number, then come back to court.
Thank you, Judge.
And I'll write that the defense is to approach well before trial if there's an issue with the rank and badge numbers.
And if you, Judge, I have my phone out, but I'm just taking a note.
Sure, oh, no problem.
Thank you, Judge. Thank you. Thank you, Judge,
You're
for
welcome.
that indulgence.
All right, and then number 6.
There is no issue with that request, Your Honor.
All right, is there anything else?
As to the motion and the specific order attached, Your Honor, I would just ask that if the defendant needs to physically pick up any tangible items that are not able to be transferred via e-discovery, that they come pick them up here. They're in the building every day, and I don't have a work vehicle to take them to his office.
Okay.
And we're fine with that, Your Honor.
All right, so I'll put on here. All right, so State, have you gone through each order that they're saying they want 48 hours, within 48 hours of the time it learns or obtains discoverable matter?
Yeah, Judge, if it's within 20 days prior to trial, yes, we're gearing up for trial, that's fine, Judge. I'm pretty.
All right, so you've read through the order and you have no objection to the court signing the order as is, but the court will add the line that if there's anything that needs to be physically transported, the defense needs to come and pick it up from you?
That, and just with the provisions regarding the product, if that's somehow incorporated into the order, that will probably not be turned over without inspection.
All right, so if you all will write the additions to the order, the court will sign it. And then all of the other discovery has been tendered.
I'm sorry, what was that?
All of the other discovery has been tendered because the last time we were here, it was the complainant school records, CPS, any additional records, the IDR, dispatch received, calls for service, statement made by the school nurse.
So regards to those items, Your Honor, we had turned over CPS, defense police, there's items missing. We're gonna send a more specific to Davina to specify those items and see if they're turned over. There was some body cam that defense believed existed. We asked about it. I just found out this morning that that body cam does not exist any longer. It did once, it no longer does. We're getting an affidavit of no record, and I've provided a written disclosure to defense regarding the restriction. As far as the IDR, CAD, all of that, there's one thing that relates to those items, and we have turned that over to defense. The nurse's statement was turned over. We clarified with the nurse or with the detective that the only statement made by the nurse was the nurse's reports. And so we've gone through each of those items. The only outstanding issue is the affidavit of no records for those body cam videos and the requesting the CPS to see if there is additional material that can be disclosed, can be turned over. We did request all CPS records prior, but sometimes if you don't specify videos, documents, et cetera, sometimes they don't mind doing it.
All right. Defense?
That is an accurate depiction of where we're at, Your Honor.
All right, so this is what's gonna happen, and this will be your last setting for discovery, and if there are items that are missing, or you see that when we have this next hearing, that there are gonna be items that are missing, you need to subpoena witnesses to have them here. They can appear by Zoom if need be, but this will be your final discovery. And also on this date, state if you have not, you'll need to tender an offer to the defense.
We are in negotiations with the medical personnel. I don't think we have a firm one at this point, but we've been talking.
All right, so Ms. Ferguson, recall this for March 27th.
I'm sorry, Judge.
Yes.
I'm unavailable on that date.
Okay. Oh, I'm so sorry to hear that. What is a good date for you? I was just trying to give you a longer setting.
I'll be back the following week, the first week of April, Your Honor.
Right. Norma, put this then on April 1st. And if you all don't have the remaining of the discovery, then witnesses will need to be subpoenaed to be here on that date,
I'm so sorry, Judge. What was that date?
April 1st. You're welcome. And defense, if your client wishes to appear by Zoom, your client can appear by Zoom.
Thank you, Judge. We appreciate that.
And what page is she on, Ms. Ferguson? All right, if you can have a seat. Thank you so much for dressing appropriately for court as always. Just have a seat and the coordinator will bring you your reset form. And once you sign the reset form, you're excused.
Thank you. Have a great day.
All right, thank you. You too.
So that brings this hearing to a very important conclusion. Beth Nicole Martinez was on deferred adjudication for aggravated assault with a deadly weapon, and the state alleged that she violated condition number 2 by failing to submit to required drug testing. Martinez pleaded true, which allowed the court to find the violation true and left the possibility of adjudication and up to 20 years in prison on the table. But rather than immediately imposing that maximum consequence, the judge chose a treatment-focused path. Martinez was ordered to remain in custody for an updated TAP evaluation, follow its recommendations, and undergo an updated evaluation as ordered by the court. The judge also imposed a restriction that she have no residence with minors. What makes this hearing especially compelling is the balance between accountability and rehabilitation. The court clearly acknowledged that people experience devastating personal circumstances, but also emphasized that being under felony supervision comes with responsibilities. The message was simple. Hardship may explain a setback, but it doesn't eliminate the obligation to communicate, comply, and seek help. Martinez ultimately chose the evaluation and treatment route instead of accepting the 3-year revocation option presented by the judge. What do you think? Did the judge strike the right balance between accountability and giving her another opportunity for treatment? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.